Hey, I think we're live, Stephen.
All righty. How is everybody doing today? John, thanks for having me on again. What do we call this? Legal ease. We bring this, every couple of weeks to your community and mine to make it easy for folks to really just kind of dive in, interact, engage, share your comments, and talk to us about everything that's on your mind credit repair wise. So what's going on in your world today, John?
Just rocking along and, going after the bad guys. And I don't know if you got my message. There was an 11th Circuit case that came out yesterday that's just got the debt collection world and here's a Southern term for you. They're having a come apart, okay, over this 11th Circuit case. And what this 11th Circuit case basically held is you've got a debt collector that sends out personal information to a vendor who then prints the collection letters. And some lawyer in Florida sued on that and said, hey, that's a disclosure to a third party, to this vendor. And shockingly, the 11th Circuit's like, yeah, it is. And the debt collector was going crazy, like, this is going to destroy the industry. And the 11th Circuit goes, hey, take it up with Congress. We just apply the law as written. If Congress doesn't like it, they can change it. So
what part of the law are they supposedly violating there specifically?
So in the FDCPA, you can't do what's called a third-party disclosure. So basically, anybody other than the consumer spouse, or the lawyer. Now, there's an exception. You can communicate credit information to a bureau. But here they're communicating, it'd be like if there's a letter being sent to you, Stephen, they would send the data to the vendor. It says, this is Stephen, here's his address, here's how much he owes, here's the debt. And 11th Circuit said, hey, boys, this thing, we're just interpreting it as written. That's a violation.
Well, like if they send an Excel sheet of 1,000 people that they want to print debt collection letters for to a print shop, is that a violation, or is this a little bit different than that? Like, what's the scope of it?
Yeah, if it's got any detail, if it's got, like, here's the amount of the debt, which it normally would, because they would put that in the collection letter. And so if you sort of listen carefully and hear weeping and gnashing of teeth, that's the debt collection industry right now.
Hold on a second. I just want to make sure. I mean, we really shouldn't laugh because we get screwy laws like this all the time. Like, we've got the telemarketing sales rule. Oh my God. So we shouldn't laugh because, karma comes back. But so basically, debt collectors cannot use, like, if a debt collector goes to FedEx office and prints off a bunch of letters and that stuff is saved on a little FedEx office, like the little computer that's in their copier printer thing, like, is that a violation?
I don't know. I mean, this was specifically a vendor that they would send sort of a mass number to. And the court said, look, maybe you've got to stop using vendors. You got to print your own stuff. And so it raises a lot of implications. And right now they're scrambling on that. So that's been sort of amusing to watch.
That is insanely wild, man. So, well, especially from your position, because you sue the bad guys, I'm going to, interestingly enough, try to take an impartial position, which is unusual for me, just because, you never want to laugh too hard at these people, because then you get God smacked. The next thing you know, you're like sucking your thumb, like, oh my gosh, what happened to our industry, the credit repair? But that is crazy. I mean,
bad rulings. It's nice to see a consumer ruling.
It is. That's interesting stuff. And that's kind of on the heels of the fact that now the debt collectors at some point later this year will communicate with consumers via social media. Is that correct? Which means if you flip it around, I can go to my Facebook Messenger right here and go to, like, Portfolio Recovery if they've got an account with me, and, like, I can send them a dispute in writing via Facebook Messenger, and it's now going to be like a legally binding communication. Is that am I on the right page there?
Yeah, so November 30, but Biden is trying to delay this by, 2 or 3 months, maybe more. And, but yeah, it'll be really interesting, because what the collectors want is to text you, send you a direct message, but they don't want you to be able to send a dispute letter that way. In the CFPB, the way they word it, it's like, hey, if it goes one way, it goes the other way. So
yeah. Now,
Yeah, so
I mean, obviously, this is a brand new case law that you just mentioned, so we're just kind of passing around ideas. But do you think if the debt collector would have some sort of an agreement with the vendor, some sort of I don't know, like with HIPAA, HIPAA specifically says that, the medical facility can have affiliated party agreements and it's all good. I mean, obviously the FDCPA doesn't make any allowance for having contractual agreements, but I mean, do you think if they make some sort of a contractual agreement that could satisfy the judge's requirements? Because if not, it's kind of like they can't even have any 1099 contractors working in their office because there's no difference between a 1099 contractor or like a
right.
vendor. What do you think about that?
Yeah, I don't know. It's going to be interesting. And like I said, the defense side is scrambling, trying to figure this out. And, the funny thing is, so there was a ruling by the U.S. Supreme Court on the TCPA, so auto dialers, robocalls, text, and it was a 9-0 decision, and it went against consumers. And the court just said, look, we're just applying the text of the law. And basically, if you think we're wrong, then get Congress to change it. And that's what the 11th Circuit did. And so all the defense people were like, oh, this is so great. Just apply the law only as it's written. And this is fabulous. And now this opinion comes out. They're like, they can't do this. This is unfair. You can't really apply the law as written. So the hypocrisy is always amusing.
Interesting stuff, man. Very interesting. So again, for everybody watching us live, feel free to put in your comments below, and John and I are gonna kind of take this thing and start to answer your questions and stuff as well. So, man, that's what's going on this week in debt collection, John.
Yeah. So let's see. Ben Traylor, who's a friend of mine, says, "Can you break the new ruling from the 11th Circuit one more time?" So the short version is that a debt collector, well, let me start with the general rule. Debt collector cannot reveal anything about you or the debt to a third party. Well, who's a third party? That's anybody other than you, the consumer, your spouse, or your lawyer. Now, there's an exception. They can send it to credit bureaus. And so this debt collector would take a whole list of people and send it to basically a print shop, a vendor. And this is very common, particularly in the mortgage industry. And then that vendor, they had name, address, amount of debt, and they would print the collection letters. And 11th Circuit said, you violated the FDCPA doing that. So that's all the screaming and crying you're hearing is because of that decision yesterday.
That is wild stuff, man.
Yeah. So let's see here. Marnay Kennedy says, I've been sending the bureaus a letter with the law and copy to remove it 1681B(a)(2), and it gets deleted. So, Stephen, what are your thoughts about that particular section?
Well, 1681B is where your permissible purpose is. So I guess, are you disputing an inquiry? Are you asking that, do you have a permissible purpose for the inquiry? Or, because if the trade line is reporting itself, so 1681B is not really a dispute mechanism. It's really just spells out the different permissible purpose reasons. So, I guess my question is how are you tying the permissible purpose into your disputes? If you want to maybe, follow up with another post, I think that might help us hone in on that. What are your thoughts, John?
Yeah, let's see. Here's a follow-up. What about the C&D? I assume cease and desist. Trump does it all the time to stop debt collectors. So, Trump is never one to shy away from litigation or sending cease and desist letters. I think he sent one to the Republican fundraising arm saying, don't use my image. And so we certainly can do cease and desist letters to collectors. Now, that does not stop them from credit reporting. It literally stops them from communicating with us. But they can sue you, they can credit report. So, and then what Stephen said about, maybe you can just drop a little bit more clarification. Are you deleting inquiries, or what are you using 1681B for?
I do see she commented down there. She says, I didn't give them permission to advertise my debt. Okay, so yeah, I can appreciate your thought process and your frustrations. Maybe John's better to talk about this. Like Congress has spoken, and Congress gave them permission to advertise if as long as it's truthfulness. They can report truthful information. So write to your congressman, as they say, right, John?
That's right. That's right.
Vote them out, and get you some new ones.
So Muriel, good to see you again, Muriel. So good to have you on here. And let's see, here is Fern Money. Is the 30-day time period for credit agencies to respond to a dispute still in effect, or has it been extended to 45 or 60 days? Thank you for your feedback. You want to take that one, Stephen?
Yeah, last I saw a couple weeks ago, the CFPB did a release where they said that it was going back to 30 days. So as far as I know, it's back to 30 days.
Yeah, and so let me give us a little bit of context. So when COVID first hit, the CFPB told the bureaus, you can have more than 30 days and we won't basically penalize you for it. But that did not change what the law is to respond to our disputes, for example. So whether the CFPB sort of hammers the bureaus or not, doesn't matter to us in terms of suing the bureaus. Congress gave them 30 days, they got 30 days, and they don't get any more time. Now, we've been suing the bureaus, and they talk about, well, we're basically shut down because of COVID and we can't conduct any business. I'm like, y'all are still reporting on me. You're still pitching all your products. You're still selling to everybody. Like, the only part that this is shut down for the bureaus is just the part about actually doing disputes. And so
and I think it's important to note, you had kind of touched on it, but the law was never amended. So I mean, technically
right.
it was always 30 days. It's just that the regulator was kind of like, which way we're going here. Give them just a little slap on the wrist. So the law has never changed, but as far as the regulators, yeah, I believe the PB is back to 30 days. But again, we'll really see what happens with that. To be determined, right?
That's right. So let's see. Tayton says, is it necessary to quote the law when disputing inaccurate items? So I know I have very strong feelings about that. I think you do too, Steve. So I'll let you take the first shot.
Yeah, I mean, with very rare exception, and maybe if you're sending a letter that's, its authority comes from, maybe like a UCC letter or something, maybe you'll say like, this is a UCC request for a statement of account. But I mean, if you're sending just a regular dispute or FDCPA, their processes are designed where they're required to conform to the law. And so really what your duty is as a professional is to put them on notice of why you're sending the letter, which is, here's what's wrong, here's why what's wrong. So, more importantly than telling them, well, here's the law where this letter comes from. Hey man, I'm sending you this letter in plain English. Your stuff is wrong and here's why. And that's where we talk about Metro 2 is so important, because they have their own industry standard for accuracy. And so it's like, well, it's reporting 3 different ways on 3 bureaus. You guys all have one standard or whatever your issue is. And if the FDCPA, I mean, the same thing, please validate, please give me a copy of my original contract, please do this. So I almost never quote, and also never quote case laws. That's, I think, the kiss of death if you quote case laws.
Yeah, there's just really no reason to do it. There's no magic language. You say, this is wrong, fix it, explain why it's wrong. Okay, so now there's nothing incorrect about quoting the law. You just run the risk that maybe you don't quote it exactly right. And I would rather people just focus on identify the specific legitimate errors, explain those errors in detail, tell what you want, and really that's all you have to do. And let me, just in case somebody wants to read it, hopefully this comment will come up. This is a link to the 11th Circuit website, and you can read that decision. It's called the Hunsign versus Preferred Collection. Came out April 21st, so literally yesterday. And let's go back to our.
Is that one of your cases? Did you set that case law right there?
No, I'm not smart enough to do that. Let's see here. Facebook user says, I have a client just received a collection letter and clearly stating the account was sold in 2011, but they're trying to collect. Is this something sent to an attorney? So it's a really good question. Let me mention this. There are 3 time periods for a collector to collect. There's to sue you, and that's the statute of limitations, tells us how long. There's credit reporting, and that's that 7-year obsolescence. So basically, you go into default, delinquency, 7 years from then. But to just call or write, there really is no time limit. Now, having said that, they have to be very, very careful in what they do. They can't suggest, in your example, that they would credit reports too old. They can't suggest they would sue unless you have a really long statute of limitation in your state. So they have to be very careful, and they may even be required in your state to say, hey, look, if you pay any money, that might restart the statute of limitation. And so they might have to warn you about that. So I would have a lawyer in the client state look at that and just see if it's, okay, not okay. And but just in general, they can, make a collection attempt by letter, by phone. They just have to be incredibly careful doing that.
Let me kind of add to that. So that's Timothy Williams, by the way. Great question. And so I would say that under your state laws, in fact, there's I think maybe like 2 or 3 states that have passed state laws, John, that actually if the debt is beyond the statute of limitations, you've got to put the consumer on notice and it extinguishes it. And there's actually as of last year, there's new Metro 2 code for the status, and it's actually debt extinguished under state law. So they've actually got a new status for debts. And I looked at that. I was like, well, isn't that interesting? And they kind of explained it that there's a few state laws. So like John was saying, I think it kind of depends on where you're at. But some states, I guess, are the Wild West. Other ones, I think they've got laws where they make it pretty clear if the statute has expired. The word that they use is extinguished. So, I'm not an expert on the subject, but I did find that was kind of interesting that the winds of change seem to be changing a little bit on the state laws, where they're doing things. Because like John, you were saying, even if the statute expired, they can still talk to you, and if you want to pay them, they just can't sue you. But if some of the states are actually changing laws where it's quote unquote extinguished, then they can't even get you. I don't even know, right? How does that even work? Can they even try to collect? Who even knows? But yeah.
Yeah, so there are a couple states where once you reach statute of limitation, the debt literally goes away. But most states, the statute of limitation is a defense that we have. And so we have to raise that in court. And actually it was an Alabama judge probably 25 years ago said, if you sue after the statute of limitations, that's unfair conduct under the FDCPA, Fair Debt Collection Practices Act. So that's 1692 F is for unfair conduct. So there are a lot of ways the debt collector can sort of, it's like running around with, a couple of pistols in your front pocket. It's like this could end badly for you. You might want to rethink this.
But let's touch on that real quick, because if you make even a partial payment, a $1 payment, that'll restart that statute of limitations. And so that's why it's kind of dangerous when these folks call you. I guess, correct me if I'm wrong, John, right? But, if you've got, even if it's not time barred, when you make a payment, that kind of restarts the clock, and it is beyond the statute, and they call you and they're like, hey, we're from XYZ Debt Collector. We love you. Just make a good faith courtesy commitment to us, easy $20 just to show us, and then boom, when you make it, that actually restarts that clock. Is it right, John, or am I kind of wrong on that one?
It can. Now, I'll tell you, for example, in Alabama, if you make a payment before the statute of limitations expires, then that's going to extend it. But if it's already expired, there has to be a written agreement signed by the consumer and a payment. Now, the debt collectors will say, no, all we need is a payment. And so, but that example you gave, Steve, where they call you and they say, well, just make a good faith payment. If they're going to claim that restart statute, then that was deceptive to hide that from you. Because fraud is 2 parts. One is a misrepresentation. That's, I tell you, Steve, that I've never rolled back the odometer on my car you're buying. Okay. Suppression is, I know when you hit 30 miles an hour, all four wheels fly off my car. And I'm like, yeah, I'm not going to tell Stephen because he didn't ask me. Well, both of those are fraud. So let's see. Ben says, recent video discussed a new rule about evictions, disclosure of rights to a tenant under CDC. So let me just say what that is. So, Stephen, I don't think we've talked about this, but the CFPB just like, boom, amended the FDCPA effective May the 3rd. And the rule is if you are a debt collector dealing with evictions, so basically an eviction lawyer, you have to tell in writing the homeowner or the tenant that they may have some protection under the CDC rule that basically stops evictions. I mean, as long as you can say, I've been affected by COVID, I'm doing my best to pay, and I really have no place to go, then you're not to be evicted. And so that's just like this sudden change to the FDCPA. Normally there's like a 2-year process, and this is, they're like, hey boys, we're doing this in 2 weeks. And so that's what we're talking about. And Ben says, would the same apply to abandonments or to pre-COVID violations? I don't think it would, Ben. Not to my knowledge. I mean, I think this is very, very specific to the CDC. And so it's not going to really impact anything else. But it does show that this CFPB under Biden is, being a little more aggressive. And again, the collectors, the eviction lawyers are like, whoa, we can be sued, because the CFPB is like very direct in their statement about, you have personal liability under this. We can come after you, CFPB. You can be sued. I mean, they're not being very subtle about it. They are like wanting to scare the daylights out of the eviction lawyers. So let's see here. Stephen, I have a client who paid several medical collections in April 2020, and in November they reported it late of the account and dropped the score, and now they don't qualify for a mortgage. So I guess my first question would be, was it reporting in April, or was it just you paid it in April and then in November you started reporting? And then the second thing is, are you saying that in November 2020, it shows for the month, November 2020, that it was late that month? Because that would seem to be impossible to be late if you paid it off in April. And so I think there's all sorts of problems with that, particularly if it costs them a house. Even if you haven't disputed this, because it's the FDCPA, then we can sue the debt collector for false credit reporting without making a dispute. So what thoughts do you have about that, Stephen?
Well, so I guess, and this is Shar Helton, good question. So okay. I guess my assumption is that they were reporting in April when she paid it. I mean, it's not like they weren't reported and then they all of a sudden slapped it on the report in November. That would be super weird. But either so, if they're medical and they're paid, you should be able to redispute it and get them off. I mean, typically, kind of like if it was a debt collector, which they always are, not debt buyers, usually paid medical just come right off. And I mean, worst case, then you can reach out to the original medical facility, have them recall the accounts from the debt collector. Because under Metro 2, if an original creditor recalls the account, basically calls it back from the collector, that has the effect of the trade line getting deleted. So there is no reason for this account to be housed still at the debt collector. And I mean, if they've done their job and they've received the money, so what needs to happen is the account needs to get recalled. Like, so typically if you just dispute it again, it should just, and this is really primarily for medical, it should go away. I mean, if it doesn't, let me know, because that's kind of a weird deal. Let's say you said you disputed it, then in February 2021, again, they weren't removed. Let's see, yes, it was reporting as updated as paid in April. Yeah, so let's talk about that, because that's really weird that they continue to report it. What is the reason for the debt collector to still maintain that account? And if the original creditor recalls it back, like Metro 2 manual says that the debt collector should delete the trade line. So let's talk about that. Maybe we could do a follow-up on the next show, but I would think that should get removed fairly easily. And if not, we can get it ready to hand off over to John. He can pay his next month's mortgage payment on that one.
Yeah, and I would just say this, Shar, that what I'm reading here, it was paid in April, and then in November it was reported 90 days late in November, or the current status in November, and that's just absolutely wrong. And what Stephen's talking about is, yeah, if the medical provider recalls it, it'll be deleted. But even if none of that happens, and even if you get it deleted with the next dispute, still they did the damage and caused your client to not be able to get their home. So, I mean, I would definitely look at suing on that. So, you can get with me or get with one of the other lawyers in the group, but definitely check that out because, from our standpoint, we don't always have suits where we can say this bad conduct caused me to lose my house. And when we do, that's very good. And so, the reason it's a good case is because it's so bad for the client what happened, that they didn't qualify for a loan. So definitely get with us about that. Let's see here. Let me go back. Okay, that's one we did. So Laura says, seeking recommendations for dealing with collection letters from original creditor who still appears to own the debt 16 months after default. So, okay, I guess what's happening is you're getting collection letters, but the collectors are not buying the debt. They are just simply acting as a collection agency. So, in terms of, we'll do two things, credit reporting and then the letters themselves. Credit reporting, the creditor should be the only one on there. If a collector's on there, they both can't have a balance. If I owe $1,000 to Capital One and then a debt collector shows up, says I owe $1,000, that looks like I owe $2,000. Okay, that's not right. So in terms of the letters, you can dispute those. You can request what's called validation or verification. And typically, let's just say this is a credit card company, you would want to know what the contract is, because that'll tell you like what are the late fees, what's the interest rate, what's the over limit fees. And then you want the statements from the last zero up into the amount that's owed now. Now, they don't have to give you all the statements going back to the beginning, but you would want them from the last time it was zero, and then compare that to the contract and see, did they do the right interest, the right late fees, right over limit fees? And now they typically won't send that to you, but it's a great thing to ask. And a lot of times when collectors get that, they're like, whoa, we'll step off the stage here. And so that would be my suggestion.
I kind of read it a little bit differently. Like I read it as though she's getting collection letters from the original creditor, like American Express is sending her collection letters.
Oh, okay.
In which case there wouldn't, like the FDCPA per se wouldn't cover, but a lot of state laws have state versions of your debt collection laws where you can still, where they actually cover original creditors. So I don't know what state you're in, Laura. But John, what is your take on that if it's actually original creditors trying to collect on their delinquent debt?
So because of what you said, Stephen, there are a lot of states where original creditors are basically subject to a state version of the FDCPA. So think of like California, Florida, Texas. Generally, if you write a sort of a quote validation dispute letter to an original creditor, they tend to respond to that because it's kind of hard for them to say, oh, wait, let me look on a map. Okay, you don't have a state law, so we're going to ignore your letter. It's a little dangerous for them to do that. So I would still ask for that type of information because most likely it will go to a third-party collector or it will be sold. And so if you can get that information, that's helpful. And you also want to know things like, is there an arbitration agreement? Now, actually, you can go to the CFPB website and basically find every credit card agreement and see, is there an arbitration agreement? That can be a strategy to demand arbitration. But I would just start off sending a letter, whether it's to the collector or to the creditor, and say, hey, give me this information, and then compare that with what's on your credit report. And
I mean, also, if it is reporting on the credit report, you do have the right to dispute directly with the furnisher. There is no, you can't sue them for violating that, but you do have the right to dispute with the furnisher under the FCRA as well. So that may be another tool. So, I mean, kind of like John said, it's going to be kind of hard for him to just take a letter and not respond to it.
Yeah, it's just psychologically, it's hard for them to do that. Because then if you file a CFPB complaint and say, I sent them this certified letter and they ignored it, they got to explain that to the CFPB. So let's see here. Lawyer by day, good to see you again. What about issuance of a 1099-C? Bureaus and furnishers won't remove it. It's unfair to make consumer pay taxes on discharged debt, still make them liable for it. Is this worth suing over? So what you have to understand about 1099-C is it saying that the debt has been discharged, or are they saying the debt has been forgiven? What exactly is going on there? I think I have like a series of 3 or 4 videos on my YouTube channel about 1099-C, going over the case law on that. It's a little bit up in the air. Kind of depends on where you live and which judge you draw. But I definitely understand the frustration of you got to pay taxes on it, and it's still on the credit report. But the basic idea is if I get a 1099-C and I have to pay taxes on that income for forgiven debt, if I then pay the creditor, they just have to report that as income, which they normally wouldn't, at least not all of it. So it does kind of balance out in the end, but I do understand the frustration of it.
So, and to add to that, Metro 2 does discuss how to handle 1099-Cs. And so the issue is when you get that 1099-C, so let's say they gave you a loan for $10,000, right? So they gave you real money for that, which you were supposed to repay. And if you defaulted on the full $10,000, if they cancel it, basically what they're saying is, hey, we gave this guy $10,000 real dollars, but we're now moving it from a loan that needs to be repaid to we just gave him money, which when you receive money, it's taxable. That's the concept there. And so the trade line really shouldn't, like, just on that account, like just a little 1099-C issue, all that really does is adjust the balance. So, if you have, they can cancel a partial debt or they can cancel the complete amount, right? Let's say you negotiate with them and they're like, okay, to use this $10,000 debt as an example, okay, we'll meet you in the middle. We'll cancel $5,000, but you still owe us $5,000. So in that case, it would update the credit reporting to show that the current balance is $5,000 instead of $10,000 because they've forgiven half of it. If they say, okay, we're going to forgive the full amount, it's the same concept. Well, they'll just update the reporting to show it's a zero balance. But all of your prior history is still, again, all things being equal, accurate because you did have a debt all the way up until the time of cancellation that was a loan that was supposed to be repaid. So really all the cancellation does is it just basically, it just recharacterizes the money that they gave you from being a loan to being taxable income, essentially. So as long as they've updated the balance to reflect the true balance of the unforgiven amount, and again, if they forgive the full amount, as long as it's got a zero balance, again, all other things being equal, then it should be, that wouldn't really be a Metro 2 or a credit reporting violation per se.
Yeah, and the last thing I'll say about it is the cases there aren't many cases, but they're sort of all over the place. Some judges are like, oh, well, it was canceled, so clearly you don't owe it. And others say, no, you still owe it. And so, again, you might.
That's because those judges don't watch the Stephen John show. If those judges watch the Stephen John show, they would know what's going on here, right? So. Yeah,
and particularly if they knew visionary is in the house. So
yeah, that's Sherry Gonzalez right there. With the little hearts and stuff. We love heart emoji.
So let's see, who is responsible for inputting the comments in the report when disputing? And if the comments are not updated, can those disputed items be updated or deleted? So Why don't you take that, Mr. Metro T?
Well, I guess, as they say, it all depends upon what you mean by your question, Tayton. I love you, man, not to confuse you, but like, what comments are you talking about? Like, there's a field for special comments, but then there's are you talking about the in dispute notation? I mean, let's just say you're talking about the in dispute notation. If you dispute it through the bureaus, they're supposed to note it. If you dispute it through the furnisher, they're supposed to note it. So, and so, like, from that perspective, that's how that goes. As far as just the regular reporting of the other special comments, like that further describe the status of the account, that stuff all originates from the furnisher. The furnisher pushes that data over to the bureaus. Now, the bureaus do have the ability to manually amend that data or correct it. They can correct or modify it. But typically, if it's the dispute notation, that should be put in by the bureaus. If you dispute through the bureaus, they're both really obligated to make sure that it shows in dispute, though. So, John, you have a different take on it?
No, I think that's right. And, we won't cover it this time, but, one day we need to have a discussion about the notation of being disputed, and then how it says, like, was disputed, now resolved, consumer disagrees, because I've got some I've got some opinions on that, and but we'll spare everybody the gory details of that in this one. But maybe we'll do that on the the Tuesday Zoom call.
Would it be nice if they added some more comment codes? Like, we had a signed contract with the consumer, but we haven't had it for years, but we're still holding him liable. Like, imagine if they had all these special codes that describe the real reality of what was happening back there.
Yeah. Sorry, we lost everything. Let's see. Fern says, my certified dispute letters were delivered to the bureaus 2 weeks ago. So good job sending disputed or sending by certified. I found numerous inconsistencies. By when should the account say disputed on my report? Thanks, God. So really, that's going to be when they conclude their investigation. So you should, start to see that in the next 30 days or so. What are your thoughts about that, Stephen?
Yeah, I mean, because they're basically supposed to forward that reinvestigation, to the furnisher within 5 days of receiving it. So once that whole thing is triggered, then, as soon as it gets finished by the furnisher and goes back to the bureaus, that's when you should see it updated.
Yeah. So Fern, you just want to make sure you're keeping an eye out for the results of investigation from Equifax, Experian, TransUnion, whoever you dispute it with. And when you get those results, I would scan them in. If you don't have a scanner, use Adobe Scan. Just, free for your phone. Adobe Scan, it's a perfect little scanner. Scans multiple pages, great. And then, sit down. And what I always tell people to do is sort of imagine you put this on your kitchen table. You've got your credit reports that then led to your disputes, and then you get the results of investigation. Then I'd pull the credit reports again, make sure you're dealing with the real credit reports from annualcreditreport.com, and then look at it and see
the real credit reports,
the real ones,
the fake reports, the
not those fake ones. And look, I say that, trust me, I've sent a ton of money to Smart Credit, but it ain't the real thing. Okay, so. At least by the end, when you get those results of investigation, that's directly from the bureaus, but then pull again from the credit bureaus, annualcreditreport.com, and then see what they fixed, what they didn't fix. And I would just literally go through my letter and say, okay, they fixed that, circle this one they didn't fix. And then you can either dispute again or get with the lawyer if they don't fix it.
But it's interesting, little like squirrel, side moment here. But, when you pull different bureau direct reports from their different sources, they still all have different formats. Like if you go to annual credit report, and then if you get the paper reports that the bureaus can mail you, and then if you go to their own portals directly, like they all look different, right? So that's just a little a little tip for you guys who are listening here. Never underestimate the power of comparing the bureau's own reports against their own other reports to find inconsistencies.
Yeah, that's definitely true. So let's see here. If a charge-off occurred 3 years ago, And a new collection agency reports the account today. Will the credit scoring system see that as a new negative item? So I think the answer is yes. Most of the credit scoring will, because it's a new collection item. They'll recognize, though, that if the law is followed, then the debt collector says, hey, the delinquency occurred 3 or 3.5 years ago. That'll be taken into account by the scoring, but it is a new collection account.
So I guess, yeah, I mean, let's kind of follow the chain here. So, I mean, let's assume that you get a charge off. So let's just say that's like a credit card. So let's assume that you've got that trade line that is reporting and has been reporting. So then the credit is already negatively adversely damaged. And then what should happen is once it goes to the collection agency, then the credit card should have a zero balance and be closed. And then the collection agency can start from that time forward. Metro 2 actually says that the date open for debt collection items should be the date that the collection was received by them. And it seems a little odd. The only thing I can think of is because, like, if you put those two trade lines against each other, like you've got the original credit card and it ends here, and then the date open of the new one is here. I mean, I've always thought that there should be like another field, like, to further describe it, But anyway, that's what the reporting standard is. So when you see these date opens on these collection items, which you're like, dude, that is not the date the account was open. It was open 3 years ago. Just understand the industry standard is designed where it is accurate to report the date when they receive it. Now, sometimes they don't even report the real date they received it, and you can dig in, and sometimes they'll have a date opened like that's later than like the payment history for the collection. They may have a few months before, or vice versa. Sometimes you'll have a date opened and then the first payment history is like 6 months later from the collection, which means they weren't reporting it every month. But kind of back to your question, though, is that, so assuming that the trade line, the collection, the charge off is reporting, and then immediately after that, the collection reports, the date of first delinquency, which is the date kind of where that 7-year clock comes from, hopefully they're not re-aging that date. So yeah, you'll have a second trade line on there. I'm not a score expert, but I would think that the score would take it into account if it can match those accounts up with each other.
Yeah. Let's see. Somebody, if I had known that, I wouldn't have put it up. Is this speaking in a favorable manner toward Matt Leistra?
I believe it is, yes. Elvis Garcia.
We were not supposed to publicize anything positive about Matt, were
we? We love Matt Leistra. By the way, cheap shameless plug from Matt Leistra, right? Credit-con.com. If you guys want to go to the premier credit event, I'll be there. I'm going to have a booth, so you can come meet me in person. Clearwater, Florida, June 7th.
Credit-con.com, right?
Credit-con.com. And dude, it's an amazing hotel, like right there on the beach. And actually, there's a discount code. Put in prelit 100 if you go in there and you check out prelit PRELIT 100, and it'll give you $100 off. So Matt's giving me a discount code to share with you guys. But anyway, we digress there. Shameless plug for our buddy Matt Lee.
Well, he's a good guy. I guess we'll give him that plug. So
yes, indeed.
Let's see. So we have, why would it be necessary for a lawyer to bring on co-counsel in a fair debt collection case? So there's a couple of reasons. One might be just not having particular expertise. Now, somebody may be really good at the FDCPA, but there's the particular debt collector they're suing. They go, hey, a friend of mine in Kansas or California or wherever has more expertise with that particular collector. And so sometimes we co-counsel together just because different lawyers have different strengths. It doesn't affect the fee to the consumer. So, there's no change there. It's just the lawyers split the fees. And so sometimes it's, you just want some help with it because we're going against, big firms. And so sometimes it's nice to have a few more troops on our side. Let's see. Terrence says, I submitted a dispute to Experian, demanding them to delete addresses and names that weren't on driver's license and utility bill. Instead of deleting, they updated the addresses. So the first thing I would say, Terrence, is the names that you're disputing, are those accurate names or are they inaccurate names? In other words, So on my credit report, so my name is John G. Watts. Okay. So John G. Watts would be a proper name. John Watts would be a proper name. And then John with my full middle name would be a proper name. Now, I only have one of those on my driver's license, but the other two would be correct as well, because I use those with, creditors, mortgage companies, things like that. So that would be the first question. Are the names actually incorrect? And the way that I look at all the personal information is there are three buckets. There's the bucket number one that says correct now. Well, that's obviously my name, my address, my phone number, date of birth, social. Then the next bucket is not correct, but it used to be correct. So maybe because of a marriage, a name has changed. Maybe I used to live at 123 Main Street 10 years ago. Now I don't. And then the third bucket is always wrong. So on my credit report right now, and I'm disputing it, it has my work address as my address. That's not my address. I don't sleep at my office. Okay. And so, if it has Watts John, well, my first name is not Watts and my last name is not John. So I would dispute that because that's always wrong. It's that middle bucket that it used to be correct. Now it's not. I dispute that. My rule is if it's within the last 2 years for an address, I don't dispute it. But more than 2 years ago, an old address, I dispute that. Any phone number that's no longer mine, I dispute. Any employer that I no longer work at. And same thing with names. I mean, if somebody has legally changed their name and, the name that was on there is, well, that's my maiden name from 10 years ago, well, then dispute it. But that would be my thought on it. You've got to figure out what is actually wrong. What are your thoughts, Stephen?
I think you pretty much covered it. I mean, one thing that can help if they are wrong, turn it into an affidavit, notarize it, and send it to them. Another little trick, though, like if you go to the TransUnion Direct portal, you can dispute personal information. And they've got a pretty good track record of deleting that stuff, and you'll get your results like instantly. You can dispute it with the other portals, the bureaus, but they're not like instant. So you may want to try disputing them just the trade line, excuse me, not the trade lines, but the personal information. You may have better luck there, but turn it into an affidavit, mail it to them. And if they still don't fix it, then, let John know and he can see what your damages are and paper it up for you.
Yeah, that was Terrence's question. So it all goes back to, it's got to be inaccurate for us to think about suing. And if it's inaccurate and we described it, we explained it, they didn't fix it, then that's certainly something we can talk about. Let's see. Do debt collectors have the ability to easily view existing debt lawsuits and results against one of their account holders? That is really a great question, and it will depend on the state. So I'll give you an example. So in Alabama, we basically are always thankful for, no offense if you live in one of these two states, but Mississippi and Louisiana, because that's the only hope we have of not being 50th in the nation, except in two things: college football and our court system. The way our court system is, our state court system, I mean, things we could do 15 years ago, a lot of, very wealthy states, they can't even imagine what we do. So 15 years ago, we sit down and I can look up any case anywhere in state, pull every document. And, a lot of states, each county has its own separate computer system. So you've got to have a login for this county and that county. And then half the counties don't have, online systems. So for example, Alabama, it would be very easy for a company to look up and see if you'd been sued. Not so easy in some other states. So now when you file a lawsuit against a debt collector, there's sort of and Stephen, I don't know if you know about this, there's a thing called web recon.
Yeah, I was going to say that. Yeah. Mm-hmm.
It's kind of like a credit report in a way. They track lawyers and consumers who sue these crooked companies. And so the theory is, if I'm a debt collector and I get these 1,000 accounts, I run it through Web Recon and it'll tell me who the troubled consumers are who like to sue debt collectors. And so that's a list you want to make. You want to be on that list because, I mean, think about it. A debt collector is like, well, should I collect this $160 debt against Stephen? He's filed 5 FDCPA lawsuits. They're going to leave you alone, or they're really dumb, which is a distinct possibility. So
don't let your bias show too much.
That's right. That's right.
Got to curb it a little bit, John.
So let's see. Laura says in California, and Stephen is right, and John completely misinterpreted my question. So sorry about that, Laura.
Right. Thanks, Laura. Thanks for pointing out the brains over here in the conversation.
So let's see. Whoa, Stephen, I can't even see you. I can't see anything on our screen here. There you are.
Eyeballs popping up over here.
I feel like when I was a kid getting a haircut, and they're like, can you sit on a phone booth?
We gotta put the little hands up like this, like we climb over it. Okay.
All right. So let's see. I have a client being evicted, and the JP Court, I think that's Justice of the Peace Court, which is sort of like small claims, I think, in Texas, says they are no longer honoring the CDC moratorium. Can you please elaborate on this? So let me, I'll pop this back up in a minute. It's weird looking at Stephen's hair right above the top of that description. So not that anything's wrong with your wonderful hair, but
my,
it was
my
just
eyebrow hair or my
no, it was up here. So,
okay.
But yeah, there are some judges, some federal judges and other judges that have said that CDC moratorium is unconstitutional. They're not going to follow it. That will all be eventually decided by much higher pay grades. Appellate courts will decide that. So suing on the creditors, credit bureaus, do you have advice or template to file against company and individual members of the company, such as officers? Do you have advice on the reasons? So I'll say this. I mean, normally we're suing like under the FCRA. We're not going to be suing the individual officers. With an FDCPA case, they would need to have some personal involvement. Okay. I mean, courts aren't really interested in us suing a member of an LLC just because they're a member. You've got to have something a little bit more than that. And as far as the template, it really just depends. I mean, you got to know exactly what you're suing for. And what I would do, I'm not sure who that was. Do you know who?
I think that was Alonzo. I think it was Alonzo Tisdale's post.
Okay.
Sure.
I would just get with, a lawyer there in Texas to work on that with you. And, they'll sort of have their own forms and how they do things. So that would be my thought on that.
You said, yeah. So yeah, you message me, Alonzo, and I'll get you connected with somebody that can, in the great Republic of Texas here, that can get you taken care of.
Very good. Let's see. Miss Kiki, PRA, is stating they will remove trade lines after 30 days on their website. Does this also apply to claimants agreed to settle debt with PRA's attorneys? So, yeah, what you're talking about there is PRA, much to the displeasure of the credit bureaus and the debt collection community, quite a while back just announced on their website, hey, if you settle with us, boom, 30 days, it's gone. And that should apply if you're in a lawsuit. But even if you're not in a lawsuit, doesn't matter. You got to get that confirmed. I mean, you can't trust the website because they go, oh, well, that's out of date. I mean, even if you just called them up, you still need to get verification from them that, yes, we will delete in 30 days. But I feel very confident they will with the lawsuit. Just ask the lawyer for PRA to promise you that. And if they lie, you sue them.
Pay to play. That's what we call that. They call it pay for deletion. We call it pay to play. Isn't that something, huh?
That's right. Let's see here. So we have smash the like button, which that's what all the YouTube people say, right? So thank you for saying that for us, Mira. Let's see. This goes back to a previous question. They did not update the balance in this instance. So I am.
Okay. That was the 1099-C.
Oh, so, yeah. That's right.
Yeah, I mean, if they did not, and you want to just make sure that the date reported is a date after the cancellation period. So I mean, as long as it is fresh reporting, then you found yourself an error right there, my friend. Because it should be updated to whatever the canceled amount is.
Yeah, let us know what happens with that. And let's see, Tayton says this was the thing about who supplies the comments for the in dispute. So we're going to cover that at some point in some detail, because basically what happened is the FCRA says if you have a dispute with a furnisher, and then the courts have said if it's what's called a meritorious dispute, then it has to be marked as disputed. So the credit bureaus who control Metro 2 said, well, we want to change that to sort of take away the impact of that. So they came up with this stuff, was in dispute, now resolved, consumer disagrees. And, there are those of us on our side of it that think that is not in compliance with the law, maybe in compliance with Metro 2, but
maximum possible accuracy, huh?
Yeah. So, I'm not sure how they can read everybody's mind. How they know I still disagree? I do, but how do they know that? And how do they know it's been resolved? I don't think it's been resolved.
Because they know that 100% of the consumers in this world hate them. So they just
That's right. Let's see. Antonio says, so I have $50,000 medical debt from surgery center because my insurance did not pay out. I disputed the debt for validation, and the collection agency sent me an itemized bill. So, okay, here's a follow-up. I believe it's a HIPAA violation. My plan was try and negotiate surgery center because I would think they'd rather forgive the loan than be fined for the violation. Is this a reasonable outlook? So I'll give you a quick thought, and then Stephen will tell you his perspective. I don't think that's a HIPAA violation, personally. I think if you look at what you agreed to, you would have agreed that they could transfer stuff to those that are helping them to collect. And, there's no claim that you can make under HIPAA. The government could. I frankly have never heard the government coming down on them for this. So if you can get some leverage over them and work out something, I don't think they're going to just like walk away from it, but they might settle with you for something. You can do that, but I don't think that you have a real strong position there. At least that's my view of it.
Yeah, I agree, because they can collect debts under HIPAA. There's no real violation for them to collect the debt. And then, like John said, there's no private right of enforcement, even if they did violate HIPAA. So that wouldn't really be the rabbit trail to go down. But what I would say, feel free to shoot me a Facebook message. We've got a lady in our training course that John is with me, the pre-lit training course, and she's basically a medical expert. And she could take a look at that thing, and she could actually tell you behind the scenes all the things that are going on with that. So send me, shoot me a message, or if you can't, message John if you can't find me, but make sure you get to me, my Facebook, or you can send me an email, steven@stevenpalmieri.com. But get with me, and I'll get you in touch with a medical billing expert that can actually give you some real teeth on that and help you fight the good fight on that one.
Yeah, and I just put a comment up that should have your contact. Hopefully it's gone up. And, I almost accidentally put up your store with all your merchandise that you're selling. I don't want to do that. Yeah, I want them to be able to contact you, not pull out a credit card.
We have the store at stevenpalmieri.com where we got some swag. We got baseball caps, pre-lit. We've got shirts. You guys check it out on there, man. It's good stuff. We just had it launched today, actually. So,
all right. At the risk of regretting this,
you can never regret that which brings your audience pleasure. Like that on there, man.
Yeah. So y'all can check this out whenever that posts. So let's see here. We have Tate say, when bringing a case to consumer protection lawyer, what can we do as consumers or CROs to make sure we provide all the documentation needed? So, yeah, I'll say this for if it's a consumer bringing this to me, if it's a CRO, if we're looking at suing the bureaus, I really need, the following information. I want to know what the credit reports look like that prompted the disputes. and then I want to see the disputes. I want to see proof that the disputes were received, and then the results of investigation. And then I want new credit reports pulled from annual credit report or my Equifax or wherever, just to see exactly what's there. And it's basically just anything that you have. We need to see that as lawyers, because if there's a lawsuit, we have to turn over everything. And so what we don't like, and I had this happen recently, client said, I gave you everything. Okay, great. So we're in the middle of a lawsuit, and suddenly they find all these documents. And I'm like, kind of would have liked to have had those earlier. And, it's okay, but it could have been bad. So just try to get everything to the lawyer, and, or at least say to the lawyer, look, I have all these things. What would you like? And then that will put you in a better position. Let's see. Fern says, appreciate all the great feedback. Any recommendations for a good consumer lawyer in Southern California, just in case credit bureaus are non-compliant, neglect my disputes? So Mike Cardoza is in Southern California, and Shiva Bhaskar. They're both in the group that we're all in, Stephen's group, and they're good guys. You can either find them or just email me, and I can connect you with them. Shiva owns a credit repair place, and he's also a lawyer. And then Mike does not own a credit repair place; he just does litigation. So hopefully that.
Look at that! You're like he just does litigation. Like it's a downgrade below having a credit repair company. I like it. Priority's right. Us credit repair guys we're the more important ones.
Hey, I just do litigation too. We're not smart enough to have our own credit repair place.
So right. You guys do credit repair through litigation, right?
How do you suggest fighting a collection that reports 120 days late in the status?
I think that's Cindy Leeson there.
Okay.
So, I'm assuming, Cindy, that's an original creditor trade line. So it's not been converted over to an actual collection reporting trade line. Now, the TransUnion reports, they kind of by default go 150 and 180. That's just somehow their templates, will roll 120 into infinity. So is it a TransUnion report or what? But I would certainly use that as an inaccuracy, and then you can go look at the Metro 2 manual, and it shows that clearly it should go to 150 and to 180, and then 180 is as far as it goes when it keeps on rolling. So, and I guess why is it going to be reporting as a collection and not a charge-off? Like we would want to find out, why did they not charge it off? Why is it showing internally in collection instead? And then you can hit them with the 120, like, okay, is this guy rolling delinquent? Like is he paying every month, keeping it at 120 days late? What is keeping it from going to 150, 180? And of course, the consumer is probably not paying every month, 4 months delinquent. And say, well, okay, because it shows like, what are the historical payments that were received on those months? We don't have the historical information on this report to see. Why is it rolling 120? Why was it never charged off? So that's kind of where I would start with that one.
Yeah, and something that let's see, Stephen, I'm hearing an echo here for some reason.
Yeah, I don't hear an echo. So Cindy just chimed in. Okay. She said it's truly a collection. So I guess you mean I don't know. Do you mean like an actual collection account? Like if it's a collection account, then it shouldn't show never a payment. Okay. Yeah, I don't know. I guess message John and me that credit report. Let's take a look at it, Cindy, because that sounds like an interesting scenario for us to figure out.
Yeah, I'm not used to seeing a collection account show that status, so I'm not sure what's going on there. Let's see. Steve says, can a balance increase on 6-year closed and charge-off account? It really depends on the account, the law that applies. Generally, you don't see it increase, but there are some that they do. Now, whether they have the legal right, it's going to depend on the particular debt. And
I would say if there was like, I guess, interest provisions, for default interest provisions built into the contract, then in that scenario, they would have the ability to continuously increase the balance.
Muriel says, once collection is sold, how should it report? Example, Macy reports LVNV has a derogatory. Would that add has one or two on the credit report? So if Macy's has supposedly sold it to LVNV, now I've been dealing with LVNV for 15 years. I've never seen them prove they own it. So I always say that they allege to own it, to allege to have bought it. But Macy's could still be on there on your credit report, just has to show a zero balance and that it was sold or transferred or purchased by another lender. And then LVNV can be on there. You just can't have two balances because that would be inaccurate. It would look like you owed twice as much money. You have any other thoughts on that, Stephen?
You got it. They can basically kind of put them next to each other like in a historical timeline. Let's see here. And it's like the first one ends here and the next one starts here. So as long as, like John said, the first one has a zero balance, the other one can show a balance. And as long as their dates aren't overlapping, right? So then that would be okay.
So here's a question. Most debt collection lawyers seem to have a flat fee model based on balance. Doesn't that incentivize a quicker settle strategy versus tedious court case? So you're talking about the collection guys that file the collection lawsuits. One thing you have to keep in mind is in the world of collection lawyers, the court cases are not where they make their money. That's just sort of a necessary evil. You know, they make their money sending out collection letters, doing collection calls. And so they have to do the court cases to continue to get all the other cases. So, I mean, I've had some collection guys tell me for every one case they file, they may settle 40 cases. Okay. So they'll have certain guidelines from the debt buyer or the original creditor, what they can settle for. And even if it's makes terrible economic sense for your particular case, they may have every reason to fight you because they want Midland to send them another 1,000 cases next month or next week. And so, you know, you can get settlements, but just understand that, you know, they'll send some young lawyer up to spend all day in court, and that's just a necessary evil.
He's got to be the young lawyer because the old fogey, he can't handle all that in court, huh? It's too stressful.
So, all right, here's another lawyer fee. Someone wins their case against credit reporting agencies. Judge gives the lawyers their lawyer fee. Do lawyers also take from the client's winning? It really just depends on the contract. Some lawyers do it where they only get the fees. Some lawyers basically take the fees, any settlement sort of goes into a big pile, and then that's split in some percentage. So there are different ways of doing it and different strategies. You know, I would just say, make sure you understand if you hire a lawyer exactly how the fee works. And I'll tell you the way I've done it for 26 years now is when there's a settlement proposal, I call the client and I say, here's what they proposed. You know, this is something you might want to consider. And then I say, here's the bottom line to you. Okay. So if you've ever bought a car, you know, you want the drive off the lot price. You don't care what the floor mats cost. Like, tell me what it costs to drive the vehicle off the lot. Same thing with the settlement. You want to know, okay, what will I put in my pocket? And then you can make a good judgment call on that. And I think that will be helpful to you.
So basically what I just heard, Neva, I heard John basically say there's this book called The Art of the Deal that you probably need to read, and you just need to sharpen your pencil on your negotiation skills. You need to negotiate a really good fee structure when you hire your lawyers because everything is negotiable. That's what
I'll say this. In 26 years practicing law, I've never negotiated my fee. And so, yeah, I tell people this is what my fee is. And if they say, I don't want that, I go, great, let me get you a cheaper lawyer. And, you know, very few people take me up on that. So it's more of a matter of just knowing how this will work and understanding it. And then as there's a settlement that comes in, a settlement proposal, knowing what that means to you. You know, I had a guy tell me one time with a previous lawyer, he had settled I think it was a personal injury case for like 120,000, and he put like $10,000 in his pocket. And I'm like, okay, that doesn't make sense. And there are all these sort of hidden fees, and we found all these expenses, and you just want to make sure that before you agree to settle, you know exactly what that means to you. And if the lawyer says, well, I can't tell you, I'm not talking about to like the penny, but if we're settling something for a couple $100,000, we ought to be able to tell a client, well, it's going to be about this, okay? And if it seems off to you, just raise some questions and have a nice little sit down meeting. Let's see.
Everything is negotiable. Don't listen to John Neva. Everything is negotiable. So,
well, my clients like it because when I settle with the other side, I make it very clear what is non-negotiable with the other side, and non-negotiable means non-negotiable. So let's see. Somebody says it's me.
That was Alonzo confirming that he was
Okay.
the author of the prior post.
I got you. All right. So Steve says, hey guys, I have 7 accounts with 3 to 6 infractions, incompletes, inaccuracies. Need a lawyer. Can't come to Alabama from, I guess that's St. Louis, to file a lawsuit on round 4 with credit bureaus. So to some extent, yes, we do that occasionally. We'll have clients from out of state. If we can sue if we're talking about the credit bureaus, major companies, we can sue them anywhere. Other times it's better to get a lawyer in your state, whether that's just a lawyer in your state or whether that's getting us involved, and then we co-counsel with a lawyer there. So I was on the phone with a lawyer in Texas today about co-counseling for a Texas client, and I think the day before, a lawyer in Tennessee to co-counsel in a Tennessee case. So, there aren't a whole lot of us that do this type of work, so it's not surprising that we might get a lawyer from Washington to jump in a case in Arizona or something. It's not unusual. And again, it doesn't change anything with the client. So, Steve, if you just want to get with me, let me know what's going on. I'll be happy to, take a look at that and chat with you about it. Let's see. Makes my eye twitch when on the comments say dispute has been resolved. That would be both bureau and consumer came to agreement, which obviously they never. That's right. I mean, it's just flat out wrong, unless by resolved they mean, the consumer has nothing to do with this. We're the final arbitrators of everything. Maybe that's what they mean. Let's see.
Pretty much.
So we have Michelle here.
She's our medical expert there.
Yes. Okay. Yeah, definitely with her. And Antonio, okay, what the paperwork sent by the collection agency had an address that was not mine, never mine. Well, I guess the question be, it would be, is this a collection letter that somehow made its way to you? Or is this like they send you the billing statements and those have an address that's never yours? So I have seen that. So let's say 5 years ago, I lived at 123 Main Street, and then I moved right after that. And I defaulted 3 years ago, and they'll send me a statement and it's got the wrong address. Or maybe this is a better example. 5 years ago, I defaulted. Last year, I moved to a new address. They send me all these back statements and they all have my new address. Obviously, like it was a new construction. That house didn't exist. So they're just plugging in the information. So I would definitely question them about that. Hey guys, what's this 123 Main Street? Explain this to me. And, they tend to get a little nervous when you bring up these errors like that. And now, Antonio, if you were here for the first part, this 11th Circuit case, you could say, now, did you guys send this to some vendor, and who printed this? Because I need to know that. And then they'll get real nervous about it. All right, let's see here. You guys are the best. These are best things learned at 22. Stephen, you're a year or two younger than me, but can you remember 22?
Sort of. Yeah, sort of. So enthusiasm is awesome. But you're right, though. I know you're kind of joking and you're all excited, but these are the things you need to learn and learn them young and figure out how to turn into a good business, help people, and get your finances in order, man. That's true, because college doesn't really Teach how the big bad bureaus work.
Yeah, so that's awesome. You're doing this so young. That's great.
That's it, man.
Let's see. Post his address and phone number. I'm not sure if that's mine or yours. Let's see.
Dude, nobody. Oh, that was Warren Maxwell. He was telling you to dox me when I said I was going to give my email. He was like, post my address and phone number. He's basically telling you to dox me. Put my cell phone.
Yeah. Well, I put your store thing. I'm like, I don't even get a commission on your store, do I? So
I don't know. We can work that out. I guess Stephen Palmieri / is it store or shop? I don't even remember. Get your
store.
Get your / store. Get your pre-lit. Dude, like we just got the storefront up this morning. I don't even have a pre-lit baseball cap. I've got to order my own, but we're getting there.
Hang on one second here. So we'll see if we can share this here. So this is his store. He's got some book that he pretends that he wrote, and I don't know if it's real or not. He's got a computer for sale, although that's a training course, right?
That's the training course that you partake in.
Oh yeah, I send that money every month.
That's right.
And then we've got
look at the swag down there, man. You get your pre-lit brand on, guys. Man.
Yeah, that's crazy. So I'm not going to show some of these, but I'll show this one. I'm lit, you're lit, we're lit, pre-lit. So that's good. Is that your signature?
That is my signature. That's right. That is the signature edition pre-lit swag shirt right there. Exactly.
This is something you claim that you trademarked, right? Your name or your signature or something?
Well, my name, I didn't claim it. I've got the thing right back here from the trademark. My name is a trademark. Yeah. That's right. Stephen Palmieri is a brand, and that's the brand swag right there.
All right. We got all sorts of crazy stuff here. Snapback.
Look at the cap right there. And if you look really closely on the side of the cap, you got my initials there. Yeah. Yeah. Go hover over, click on it. Look at that.
Oh my goodness. Are people really going to put your initials on their head?
Dude. I mean, I've got people that are going to be at CreditCon. They're like, Steven, dude, give me some shirts. I'm going to wear those things.
That's great marketing. All right. Let's see here.
Thanks for the advertising airtime there, John. So
yeah. Just take it out of my $99 a month, right? Let's see here. I think this is a better thing. I felt really constrained the way we had our screens. Like I like to use my hands and I couldn't even see my hands, but this is better. I like it seems like we got a little more room, don't we here?
Yeah, I don't know what happened, but
well, I'm glad it only took us like an hour and 20 minutes to figure out we got to wrap this thing up in like 5 minutes.
Because it put the thing below us, didn't it? Yeah, it's pretty.
Yeah.
It was like, wait, something changed here.
I tell you what, give us only like 7 weeks, 7 times to do this, and we'll eventually figure it out.
We'll get it right again.
Medical debt violates your privacy rights under the Privacy Act. So it can, if they do it the wrong way, but just in and of itself, medical debt, does not violate your privacy rights. But they certainly can do it the wrong way. I mean, they start sending like a postcard with, listing all your procedures that you've had and, sending it to family members and other people. That can definitely be a problem. Let's see. I think this was Cindy saying it was a collection account. That's just mind-boggling. Let's see. I was having trouble with the website, leaving my contact info. What would you guys recommend the steps I should take for this $50,000 debt? So Michelle is the medical billing lady, right?
Yeah, but you can just email me, Steven at stevenpalmieri.com, and I'll make sure I'm going to get you connected, or just send John a YouTube. Maybe technically I've got a YouTube channel, but I don't really do much with it. So reach out to John or me, and we'll definitely get you connected with Michelle Peoples. She's the medical billing expert.
Yeah, and so I put Steven's email and then my website as well. So let's see here. Okay. So once trade line goes charge off on your credit report, should it be reported as a charge off just once or charge off every month? And Laura, this is an incredibly frustrating thing. And unfortunately, we have bad news for you, which is it should really report every month as a charge off.
Because it's the current status, right? So you're looking at, like, think of a credit report as every month it's like this three-dimensional picture. So really all it's telling you is that at that month, the current status at that month was that it was in charge-off status. So that's what you're looking at there, is the historical information for that period of time.
Let's see. Somebody says, what common violations or ways to attack Midland funding do you see and recommend?
That's Warren Maxwell. He's just jonesing to sue Midland. That's all he wants.
So, there's the E8 violation. That's always a good one. Send just a dispute letter. Or, one tactic on the sort of pay for delete model is you call up the collector. And as long as they say the call can be recorded, you record the call and you say, hey, I dispute this debt and I want to talk to you about settling. And, you clearly said you dispute the debt, but a lot of times all they care to remember is I want to talk about settling. And then you talk about it and see if they'll do a pay for delete. Even if they won't, you still disputed the debt. You can dispute it verbally. And then you check, see if it's been updated as showing disputed. If it hasn't, then you have an E8 case. But, a lot of these debt buyers, in some ways you really need to wait for them to sue, because the courts have been pretty protective of them as far as credit reporting. And when you say, well, I don't think Midland Funding really owns the debt, the courts say, wait a minute, go win a lawsuit against them and then dispute it. Okay. So that's the nature of the beast here. Let's see, get the bottom line. Yeah, that's right. On any settlement, you want. Asked this incorrectly for the consumer defense lawyers. Okay, I got you now. Consumer defense lawyers have flat fee models to defend the debt lawsuit. Doesn't that incentivize them to settle rather than go into a tedious court case? Well, I can tell you, I do debt defense in Alabama, and we do it on a flat fee. And our fee is the same whether we settle it the day that we get in the case, which some we do, or if it takes 2 years. It's just a flat fee. And so for me, it's very simple because I won't pay the debt buyers any money. If they want to settle, it has to be a settlement where they get no money. So if they want to agree to that in day 1 or day 50 or the day before trial, then they can do that. But otherwise, we go try the case. And that's what I was hired to do. But also, if you want to think about it from an incentive, I want to go win that case and then sue that company. Because I make money defending people, but I make a whole lot more money suing these guys. So, we have an incentive if they won't settle to beat them and then sue them under FDCPA, FCRA, whatever violations are there or can be there after we dispute it. So, it's something that you want to make it clear up front what your parameters are as far as settling. You may say, well, I'll pay 10 cents on the dollar, 50 cents on the dollar, 60 cents on the dollar. Just make sure the lawyer and you agree to that, and I think you'll be in good shape on it. Let's see. I love my co-counsel attorneys.
That was Sherry Gonzalez, and hard to believe we've been here almost an hour and a half already, man. It's kind of crazy.
Yeah, we got to get you off the phone. I know.
Time flies when our fans are over here.
Let's see. To CRA, they use third-party credit reports when disputing and have a client that needs representation to either sue bureaus or company. Would those disputes not be helpful since third-party credit report? Yeah. So, I mean, you certainly can use, whether it's Smart Credit, Identity IQ, or mortgage brokers, tri-merge. We just want to see when the dispute happened, what did the bureau say in response? And then we want to see the actual bureau reports. So we can definitely use tri-merge, Identity IQ, Smart Credit, but at some point we need to see it directly from the bureaus, because otherwise we're relying on this third-party company to actually communicate it correctly, which they don't always do. Let's see. Steve looks like 22 was last year. Wow. Who did you pay? Did you send them from some free swag to say that?
I think that was Warren Maxwell as well. He's trying to give him a free pre-lit cap, I think.
Yeah. Well, Warren's going a little excessive here, I think. If you had said he looked like he was 22, maybe like 20 years ago, that would be believable. That would be
19 years ago. Thank you.
All right, Antonio, they sent me a letter with itemized bill and procedures that were performed during my surgery, incorrect address to answer. Yeah, okay, so that's going back to, I think, that $50,000 bill. Yeah, I would just get with Michelle on that and see what she thinks about it. Yeah, I still don't buy the trademark thing. I think he got that off Amazon or something. So let's see. Let's see. I'm waiting to watch Steven's head explode live. Now, who wrote that?
That was
Warren again? Okay.
When you were giving me a little stage time to show my storefront with my swag.
All right, Terrence, send me an investigation report. They updated fields, but every item they claim to update is still the same, plus the date update is still reporting 3 years ago. Well, what I would do on that, Terrence, is just literally map that out with a spreadsheet or however you want to do it. Just say, okay, here's what I disputed. Here's what it said before I disputed. Here's what it says now after the investigation, and see if they haven't really made any changes. You can always dispute again with them. And again, though, make sure that what you're disputing is actually incorrect. I know I keep harping on that, but we have people all the time come to us and say, hey, I want to sue. They did a lousy investigation. I say, well, is it inaccurate? And they're like, well, it doesn't matter. I'm like, yeah, actually, that's the only thing that matters. So just keep that in mind. And let's see. Steve says, can't stress enough, reports hiring a lawyer represent you in collection agency lawsuit. Sued by LVMV gets sued quickly, no additional cost. Yeah, it's just, knowing where kind of the pressure points are with these debt buyers and what they are afraid of, that is very helpful to encourage them to do the right thing. So appreciate you saying that. Let's see. A collector lists the original creditor's professional finance trade name officially abandoned by them. It seems that the courts aren't terribly concerned about that. That you might have, like, they'll say the creditor is Chase Bank. Well, really, it's JP Morgan Chase Bank. And most courts are like, if it's close enough that's not deceptive to you, then that'll be okay. The one thing I would wonder is, normally when the original creditor is the same as the collector, they're saying that they bought it now. And so is that the case, or who was the true original creditor? Normally it should say like current creditor and then original creditor. So the current creditor could be the debt buyer if they bought it, and the true original creditor is whoever you dealt with earlier. So let's see, Steve, I can stay on for a couple moments. I don't know if you need to hop off or not.
Yeah, I've got some more hot meetings to go into here, but well, all you guys here, I appreciate y'all, being part of the show and the great questions. And John, I will figure out how to hop here, man. Here we go, leave studio. There we go. And I will let you take it away. And I'll see all you guys.
All right, buddy.
Take care, guys. Bye-bye.
Good to see you.
All right.
Yeah, and we'll just go a few more minutes here. I need to hop off. Let's see, would it be too cute for me to register the name to myself, deny owing myself anything? I don't know if that would be too cute, but it'd be funny. So let me know if you do that. Let's see. Golden Gate says, World Omni still trying to pursue foreclosure of personal property of a truck. Filed pro se answer. Hearing date was canceled. Attorney is trying the motion for summary judgment. Yeah, that's pretty common. Summary judgment motion, if they're successful, there's no trial, and they can do that by affidavits, and they don't have to fly a witness in. So I would just be very careful with that. It's hard pro se, not impossible, but it's hard to defeat a summary judgment. And you've got to know the rules. Typically, it's called Rule 56 in your state. What are the rules for how you respond, when you respond, where you respond? And you just have got to follow all those rules very closely there. So Muriel, thank you for your comment there, Muriel. And let's see. Yeah, so going back to that summary judgment, I mean, really, you've got to, if they're doing summary judgment, you have to be able to respond so that they see themselves as having a chance of losing summary judgment. But remember this, summary judgment is kind of a free shot at you. I mean, if they lose, they still go to trial. So they get to take a shot at you. If you win, you still go to trial. So you may want to talk to a lawyer in your state. I'm trying to remember if you're in Georgia. If you are, I've got a lawyer, Steve Koval. I don't know if I've sent you his information, but I would talk with Steve. If you're in Georgia, if you're in another state, just let me know and I'll try to find you somebody. Let's see. CRA says they updated the account. Does the dates last reported need to change? So typically it would, but it can vary a little bit by which bureau and exactly how it's worded there. But in general, when they update the account, there should be the date reported should be updated. Where this gets a little confusing, and say it's a charged off account or it's a closed account from 3 years ago, they don't necessarily want to show that as being a current account, currently updated, because that can hurt your credit score. So you just have to look at it, and we have to have a little bit more detail. Let's see. I sent in a dispute based on Metro 2, comes back verified. Now what? Well, that's really going to depend on, I know it probably sounds like a broken record, but there has to be errors. So Metro 2, and I kid around with Stephen a lot about that because he's very knowledgeable about it. But Metro 2 is just the reporting format, the standard that these bureaus have. We still have to have an inaccuracy. In other words, I see people do dispute letters that are like, I want you to make sure everything complies with Metro 2. That's kind of worthless. It may get something fixed, but for me to sue, a federal judge would sanction me for that. I mean, we've got to identify the specific error. So you can't just say the Capital One account. I'm not saying you've done this, but you can't just say Capital One has an error in it. You can't just say Capital One has a balance error or a status error or a payment history error. You've got to detail exactly what that error is. And then that puts a really heavy burden on the bureau when you can point out specifically what the error is, and then they don't do anything about it. That's when we have a lot of fun with the bureaus and the furnisher. So just be very, very specific. Let's see. Thank you both for this content. Your weekly. Yeah. So we have a webinar series, and Pandora, thank you for being on that. And I'll just put a link to that. If I can remember how to spell it right. How to fix. So this is a free weekly webinar. We just did our third week on this. And it's really the way my office does disputes. So literally we start with pull the real credit reports. We look at the personal or the biographical information. Today we talked about if you have a bankruptcy, if you have inquiries. The next week, probably the next 2 weeks, we'll go over how do we actually find the errors on these accounts or these trade lines. And then how do we send those and, have tools and templates and all that. So it's totally free. Anybody that wants to join in that. And so Mira says, can you explain the difference between written and an oral contract statute of limitation? Yeah, some states make those a little bit different. So really it's very, very state specific. So I was just talking to a lawyer actually that defends Midland, and he was involved in a Kentucky case. And apparently there's some controversy in Kentucky. Is a credit card 6 year or 5 years or 15 years, something like that. So it's very, very state specific. Some states are a short time period. Others are very, very long. And some states will distinguish between an oral or verbal contract. Some won't even allow those, but then a written contract. And so a credit card would typically be written. Although I'll say this, in most states, the theory that's actually used is an open account. Okay, now there is a contract, but the debt buyers really struggle to be able to actually prove the terms of the contract. And so they typically go under what's called open account, which an open account is, you can charge on it, you can pay it down, you can charge on it, just it sort of fluctuates every month. And as opposed to like a car loan where it's, $500 a month for the next 60 months. So, but that again can vary by state. I mean, this stuff gets really, really specific by state. And somebody says, thanks for all your information and help. Well, you're very welcome. Thank you for being here. Let's see, I'm specific detail on all the inaccuracies. That's great. Then I would just look at what they did, pull the reports again, and just lay all that out and see, okay, did they change it? Did they not? And if you've been very specific and they did not fix it, then I think at that point, it's time to get with the lawyer and say, okay, here's the package. And again, for me, not saying every lawyer is this way, but for me, I want to see the credit reports, even if it's like a smart credit that prompted the dispute. Then I want to see the actual disputes. And then I want to see the proof that the Bureau got the disputes, their response, and then the new credit reports to see where it is now. So just sort of think of that timeline. Something told us there were errors. And so we did a dispute letter that identifies those errors. We can prove the Bureau's got it. Here's what the Bureau's did about it, if anything. And then here's what my report shows now. And I think if you'll gather all that together, whether you get it to me or another lawyer that files under the FCRA, I think that will be very helpful to whoever you send that to be able to help you. Let's see. I'm new in Canada, lives alone, student visa, no one here to guide me. His driver's license, credit card stolen. Yeah, so if you've had a crime, I mean, you've got to get with the police on that to help you. And if credit card stolen, need to contact credit card company, let them know. As far as your license, you just contact wherever you are. I'm not sure if you're in Canada or you moved here from Canada, but wherever the licensing agency is, and just tell them, hey, my license was stolen, and they should be able to help you with that. So sorry you're having to deal with that. So excellent legal content today. Well, thank you very much. I think I'm about to totally lose my voice. I'm not sure. Maybe it wasn't such a great idea to do like 2 long webinars on the same day, but appreciate everybody being here. And this will be our last one. I have a creditor, some debt. I paid the debt buyer, but the creditor will not remove as a collection. Your take. Okay, let's see. Have a creditor that sold off the debt, and then you paid the debt buyer. So let's just give these names. Say it's Capital One, and they sell it to Midland Funding, and you paid Midland Funding, but Capital One will not, I assume you mean Capital One will not remove themselves, or do you mean the debt buyer won't remove? Typically, the original creditor can't control the debt buyer as far as whether they come off or not. The debt buyer should be 0. The original creditor should be 0. And let's see. Yep, that's it. Okay, so what I would do is, Capital One is with Capital One, you really can't force them to come off, but you can certainly look for any discrepancies. And let me just give you an example. Look at your TransUnion report, the payment history. I can almost guarantee you there's at least 2 or 3 months in there where there's just no data. It's just missing. I mean, it'll be like 30 days, 60 days, 90 days. It'll be like 2 months of nothing. Or maybe it will have the rating, the 90, 120 days, but there'll be no balance. There'll be no past due. That gives you something to dispute. So you're looking for anything that's wrong, that's incomplete, that's inconsistent to be able to dispute. And if they fix it, then hey, they fixed it. But if they don't fix it, that gives you leverage to either dispute again or to look at suing them. So we'll call it a night here on this. Thanks so much for all the great questions. And remember to go visit, let me find Palmieri's store here. Somewhere in here, I had it. Well, there's his email, and somewhere we have his store. So let me see here. Yeah, he told me he had this, clothing, and I thought he was kidding, but apparently not. So if you really love Steve and you want to wear his initials on your head or on your body somewhere, clothing, of course, you can check this out. So, hey, listen, everybody, have a good one, and we'll catch you guys in 2 weeks. All right. Bye-bye.